Hi everyone, welcome to week 6 in our series looking at key legal issues arising in the film and television industries. I'm James Whitaker and I act as legal advisor to the Film and Television Charity. Today, in the first of 2 sessions on the topic, we'll look at some of the key types of agreement or contract that you will commonly encounter when you're working in this industry. And while the agreements we'll discuss are certainly not exhaustive, hopefully they'll give something of a flavour really of the importance of understanding the types of contract that you're dealing with when working in this world. Let me start by mentioning briefly pre-production and development contracts. This is way too big a topic to cover sufficiently here. Suffice to say that from the earliest stage of your project, you should be keeping in mind getting in place the appropriate agreements, whether that's the rights agreement, the financing agreement, and of course all licenses or assignments with regard to any copyrighted work that you want to use in your project. This is a pain and will not be front of mind when you're getting your project going, but it will make life a lot easier later on. What about producer agreements? Well, the role of the producer in today's industry is significantly less powerful than has historically been the case, but producer agreements are still crucially important. Producers will typically act as independent contractors, as will their directors, actors and crew, although there are of course multiple production companies that employ producers directly. In any event, the role of the producer on any given project will vary greatly and will depend in large part on the particular producer's background and skill set. Some producers may have raised their own finance and will then have, in all likelihood, greater control over the project than a producer who has been hired by the studio. But regardless of the precise scope of the producer's involvement, the key point here is that the producer's agreement should contain clearly the key terms of the arrangement for your project. Let me turn now to option agreements, which are commonly encountered although certainly not exclusive to the film and television industry. In broad terms, an option on, say, a literary property is the exclusive right to purchase the film or television rights to that property at some stage in the future. These agreements really reflect the reality that most buyers will not want to purchase the film or television rights outright until the project is in an advanced stage, often not until the first day of principal photography, when it becomes more certain that the production will in fact proceed. Option agreements grant exclusive purchase rights during the option period, which is why they're so popular. So if the rights have been optioned, no one else can develop the project during the time of the option period. From a buyer's perspective, the main advantage of an option agreement over an outright purchase of the rights is the relatively low costs of these agreements and consequently the reduced associated risk. For example, what if a buyer purchases the rights outright but then can't secure development finance or can't find a writer to produce a sufficiently strong script? Options usually cost significantly less, say £5,000 or £10,000 for a year's option, or indeed a nominal consideration or price, say £1 or $1. Now, if you're negotiating an option, it's usually worth including a right of renewal, which means that at the end of the option period, you can seek to agree an extension. Once the option period expires, the right to buy the rights that are the subject of the option lapses. So what this means is that following the end of an option, the seller retains the rights to the project if they have not been purchased under the option. One very important point to keep in mind when thinking about option agreements is that while the agreements themselves will likely be very simple and quite short, it is usually worth trying to negotiate the purchase terms at the same time. And the reason for this is that if and when the option is exercised, the purchase agreement automatically kicks in. So an option without agreed purchase terms can be pretty worthless. I want to touch on step deals. Now, these tend to apply, although not exclusively, but tend to apply in the context of producers hiring writers. The aim of this type of deal, a step deal, is to protect the producer against a situation where he or she hires a writer who turns out not to be capable of producing the product. So step deals proceed, as the name suggests, on a step-by-step basis. The producer will have the option after each step or stage to terminate the writer's agreement. So the producer initially pays the writer just to produce the treatment. If she likes the treatment, she'll pay the writer to produce the first draft. And similarly, if she likes that draft, she'll pay the writer to produce the final draft and again for the polish. And during those reading periods, the writer is usually obliged to be at the ready to continue working if the producer requests it. And finally for today, collaboration agreements. Now, despite the huge creative potential of collaborations, they also present huge potential for disputes, usually as a result of some form of alleged idea theft. So the key point here is that anyone seeking or offering contributions to a project should commit the arrangements to paper. This can then deal with issues such as how the copyright is going to be assigned and how payments are going to be split if and when it comes time to sell the project, and other matters that are going to be relevant to the collaboration. So that's it for today. Thank you very much for tuning in, and I'll look forward to seeing you next time when we'll continue our look at some of the commonly encountered agreements in the industry. See you then.